Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of conflicts or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It's Pam Esquire, also known as Your Law Intellect. Thank you all so much for joining. Make sure you hit the like button on the way in. Subscribe to the channel if you have not done so already. I did see that you said the goal ran out. I'll have to see if it pops back up and I'll throw it back up there. But you guys know you don't need a goal. If you want to support the channel, you can hit the super chat, super sticker. We have the Cash App. However you want to support the channel, we would be greatly appreciative of such. So today we are here to talk about Tyler Perry. As you all know, he was sued by Derek Dixon. There were some allegations that are sexually related, according to him. There was some back and forth. The lawsuit was filed in California State Court. Tyler Perry moved it to the federal court. And then now once it was moved to the federal court, he filed a motion to dismiss. What is basically interesting about this motion to dismiss is that he was alleging jurisdictional issues. And what is interesting, because he's saying, listen, we have a contract and there's a choice of law that says Georgia, if any disputes happen. Tyler Perry lives in Georgia. Most of the incidents were occurred in Georgia. And so Georgia is the correct forum. What is very interesting is we actually had this conversation. And the reason why we had this conversation is because there was a man by the name of Braxton. I think that was his last name or first name. I can't remember. But Braxton, that's what I remember from the video. And he was very, very upset because he was alleging that an attorney told him that there was some statute of limitation issues because of the Georgia law would apply and all of that. And I said, I think he's premature because he really doesn't know what Tyler Perry is going to respond to this lawsuit, meaning we don't know what jurisdiction it should be in, what form. We don't know what law that they're going to apply to the claims, to the case, because that's very important. Why? Because when you look at a lot of the claims that were filed by Derek Dixon, they were all California-based claims. Also, California had a statute that was similar to what was going on in New York, how Diddy got sued, of which you can look back, even though you have statute of limitation issues. So now, I think this was the first step that Tyler Perry was doing to try to remove the case and then say, Georgia law is what applies, the state law. And so these claims may not even matter. But if you guys don't know what I'm talking about, I'm going to pull up the Braxton, when we talk Braxton Wells, that's his name. We're going to pull this up just for our remembrance because it has been a minute. Let me see. So this was Braxton Wells. After Derek Dixon filed his lawsuit, Braxton Wells came on this here internet and he talked about a lawsuit that he settled. He didn't have an issue with Tyler Perry. It was supposed to be someone in Tyler Perry's studio that he alleged had done something to him. Where there was a settlement agreement, he put the settlement agreement out there, and I was like, why would you do that? There's an NDA, there's all of that. You may end up having to pay all that money back. Well, part of his grievance was he looked at the complaint for Derek Dixon and just treated it as if it was gospel. Not that it was just allegations. You really don't know what Tyler Perry is going to respond. You don't know if these claims are going to stick. You don't know what jurisdiction is going to be a part of, but you're out here going off and have no clue. Well, as I predicted, when I said it was premature, Tyler Perry responded with a motion to dismiss, and it was based on jurisdictional and forum and those type of issues when he did his motion to dismiss. Of course, he denied the allegations, but he also wanted it removed for those purposes. So I'm going to, just for purposes of refreshing some of your recollection, I am going to play what Braxton Wells was saying and how we talked about this jurisdictional issue in this video. Hold on.
All right. I'm not about to hide anything with you guys. I'm not. And I'm not about to sit here and be afraid and be silenced by people knowingly they did me wrong. I'm calling out Tyler Perry Studios. I'm calling out Mark Swinton. I'm calling out Jeannie Harrison. I'm calling out Michael Robbins. I'm calling out Tyler Perry. And I'm calling out Mark Temple. And I'm calling out Chris Giovanni. I want you guys to know what you guys did to me was very unlawful. And me being a retired vet, U.S. Army vet, going through post-traumatic stress disorder, going through mood, depressions, everything that I've claimed in my testimony. You all covered it up. You all covered up a felony crime of what Mark Swin has done to me. I've asked for help from the California State Bar to complain to Jeannie Harrison because she didn't tell me my California rights as a U.S. Army veteran and a California LA resident. I'm sitting here looking on the news that this kid named Derek Dixon is getting unlimited jurisdiction, quid pro, as a LA resident, right? His incident happened in 2020.
So what I'm going to say is, by that comment, I was like, I don't think he understands what that even means, but we'll continue. Because like I said, unlimited jurisdiction within the court is typically they have the ability to hear any type of case that you bring to them. They're not just subjected to one type of case. That's typically what it means, a general jurisdiction, unless he got something else. Quid pro quo, it is a law that they have a lot of times.
The statute.
If you want to, come on and explain yourself, sir, you're welcome.
In Georgia in an employment place. He said he had a sexual harassment, and he was groped by Tyler Perry in Georgia as an employment place. But he's an LA resident. All right, y'all tracking what I'm saying? 2022, my incident. I get sexually assaulted and raped, drugged, blacked out. That's a felony crime. And it happened in Georgia as an LA resident. So if you guys don't know the laws in Georgia, this is what they put against me. They said I had 2 years of a statute of limitation. I got 5 months late. 2 years of statute.
And honestly, so this is pretty much what he was mad at. But let me move this up to this complaint real quick. See, the jurisdictional part may be what he's referring to. But I hope he gets the solace he's looking for. But I don't think this was See, the quid pro quo, actual harassment, that's what he's talking about. Basically saying, you didn't tell me all of my claims. This is what I think his frustration is. He's saying, I was just told in Georgia I had a statute of limitation. This attorney went over and found ways to sue, even though we honestly don't even know if any of this is going to stick. So he's saying, you didn't tell me that I had all these different claims on top, and you're the lawyer. So I think that's what his argument is. But again, we don't even know if any of this stuff is going to stick, any of it, because we don't know what Tyler is going to respond to and if he's going to try to dismiss the case or whatever. So venue and jurisdiction in the California. So he was saying he's a resident of California. He also resided in California. He's saying much of the harm caused by the assaults occurred in California. On information and belief, Tyler Perry has engaged in similar actual assaults from California. So they have to actually show how California has jurisdiction over this case. And it's probably because, as we know in this case with Dixon, he was saying a lot of the stuff happened at his house in Georgia, but he's a resident of California. So they may actually challenge jurisdiction. We don't know. He hasn't been served yet. California has a strong interest in allowing its residents to recover for injuries sustained, even if the claim would be time barred in another state. So this right here, just because he was told that the jurisdiction, that the statute of limitation expired in Georgia, I think he's pissed off saying, but I read this and there's things in California because I'm a resident that should have applied to me, but my attorney didn't tell me about that. And I wouldn't have went and settled but for me knowing that. Maybe that's what he's trying to, give. I'm working through this. Trying to figure out where he's going with it. Additionally, California law provides specific revival statutes for actual assault claims, which revise certain claims that would otherwise be time barred if the plaintiff meets statutory criteria, including allegations of a cover-up by entity. So that's why you're hearing all this cover-up, that this attorney colluded with this agent and this person knew him since they was 18. Like now you hear, or like the medical records when he said something about the medical records. So maybe that's what cover-up he alleging is coming from. So then, Mr. Dixon was a California resident while performing work for Tyler Perry from January 2023 until his termination, is currently domiciled in California. Yeah, they're going to definitely challenge jurisdiction on this. That's why I think that this attorney put so much time into, and I usually don't go over jurisdiction. So sorry. So yeah, so we talked about a lot of this and knew this was coming. I told you all. I was like, they're going to challenge jurisdiction because what is happening, it looks like, is that if California laws doesn't apply, because that's what they're going to argue, that California state law doesn't apply, that's Derek Dixon's lawsuit. And the claims of assault and battery and all of that. So Tyler Perry did file a motion to dismiss. We did do something on that. And hold on. The court did issued an order. And this is the order. Order granting in part defendant's motion to dismiss or transfer. On October 27, 2025, defendant Tyler Perry and TPS Production Services and/or Action LLC filed a motion to dismiss. On November 17, 2025, plaintiff Derek Dixon filed in his opposition. On November 24, 2025, defendant filed a reply. Pursuant to Rule 78 of the Federal Rules of Civil Procedure and Local Rule 7-15, the court found the matter appropriate for submission on the papers without oral arguments. The matter was therefore removed from the court's December 8, 2025 hearing calendar, and the parties were given advance notice. After considering the moving, opposing, and reply papers and the arguments therein, the court rules as follows. On June 13, 2025, plaintiff filed this action against defendant in Los Angeles County Superior Court alleging 1, quid pro quo sexual harassment under California rules. Work environment harassment under California law. Sexual harassment under California law. Workplace gender violence under California law. Violation of the Bain Act under California law. Sexual battery under California law. Sexual assault and negligent retention, intentional infliction of emotional distress, and retaliation under California Fair Employment and Housing. So we had a whole plethora of claims, all right? Defendant Tyler Perry is a Georgia resident who has lived in Georgia for more than 30 years. Make sure y'all hit the like button, please. It is undisputed that Perry maintains his permanent residence in Georgia, is registered to vote there, and holds a Georgia driver's license. While Perry owns property in California, including a house, he does not use any California property as his permanent residence. And they got the declarations of the people supporting that. Neither entity has offices, staff, or a registered agent in California. So that would be for the Tyler Perry Studios. And neither is licensed to do business in California. Plaintiff met Perry in 2019 while plaintiff was living in Georgia and working for a Georgia-based event company. Perry helped plaintiff secure minor acting roles in television shows, beginning with a single episode of Ruthless filmed in Georgia in 2019. Plaintiff subsequently entered into a series of contracts with defendants to appear in multiple television series and film production between 2019 and 24, including The Oval, Losing It, and Finding Joy / Joy Ridge. All of these productions were filmed at Tyler Perry Studios in Atlanta, Georgia. Between 2019 and 2024, plaintiff executed 4 separate performer agreements with an action or TPS. Gordon, that's in the declaration. Each agreement contains a Georgia choice of law. So that means within the contract, it tells you if we have any dispute, then it's supposed to happen in Georgia. That's the choice of law. Saying that the jurisdiction is Fulton County and applying Georgia law. And they show all the agreements from the Oval, Losing It, Finding Joy, Ruthless agreement. So all of his agreements say, hey, if you have to bring me to court for anything, Georgia law applies, not California. Georgia is the law that applies. Plaintiff alleges that between January 2020 and June 2021, defendant Perry engaged in unwanted sexual advances and physical contact during encounters in Georgia, the Bahamas, and Wyoming. Specifically, plaintiff alleges incidents in January 2020 at Perry's Georgia's residence, in March 2020 at Perry's Georgia home, in August 2020 at Tyler Perry Studios in Georgia, in October 2020 during a cash trip to the Bahamas, and in June 2021 at Perry's home in Georgia or Wyoming. In January 2023, plaintiff moved from Georgia to Santa Monica, California. So Derek moved from Georgia in 2023 to California. After his move, plaintiff continued to work for defendants, filming season 6 of The Oval in February of 2023 in Georgia and appearing in Finding Joy, filmed in February 2024 in Georgia. The Finding Joy agreement, executed in 2024, lists plaintiff's Santa Monica, California address for contractual notices and was entered into between defendant TPS and Derek Dixon, LLC, a Georgia limited liability company. After plaintiff's moved to Santa Monica, defendants sent scripts and paychecks to plaintiff's California address as part of plaintiff's employment. Plaintiff's duties under the performance agreement, including off-camera tasks such as script study, memorizations, practice, and preparation, which plaintiff performed from his California home. So basically, Dixon was trying to do his best to try to say California is the proper form. This is why when Braxton Wells was going off, I was like, this is just an allegation. So we don't know. He's going to fight jurisdiction. If he fights jurisdiction, all these claims that you're alleging and saying that these attorneys misguided you or they're all colluding and nobody wants to fight Tyler Perry and all of that may not even be accurate because he's in the wrong court. So those attorneys could have been giving you sound advice and telling you the truth that, hey, your best bet is to try to settle this case and get what you can get because you're going to have statute of limitation issues if we apply Georgia law, which is the correct law. And so he was going off and put up the agreements and put up settlement agreement and all of that, which was interesting because he didn't come out until after I think they made their last payment to him, if I remember correctly. And I was like, you could end up on the hook for all of this money for no reason. We don't know if this is just an allegation. We don't know if any of this is going to stick. I mean, I think when the Cassie Phenom happened, where you had Diddy that settled within 24 hours, I don't know if people just thought that is something that may occur, but that you're playing Russian roulette with that. Everybody is not going to just say, here go the money, and think it. Once a lawsuit is out there, to me, it makes no sense. And we've all read it and the public has dissected it. It doesn't make any sense for real. You might as well go through with it and see what happens at this point, because people either going to believe it or they're going to wait to the end. People are going to, of course, the public opinion may affect you if you're a public figure. But for Tyler Perry, I don't see where this had really affected him. Honestly, I didn't see where this really affected him. But anyway, so they go on to say all the different things that he's saying occurred in California. Plaintiff alleges that after moving to California, defendant Perry would call him and make inappropriate or unwanted sexual comments. So he's trying to say contacts because he was living in California when allegedly Tyler Perry was making some of these comments. Plaintiff further alleges that he reported the harassment to defendant TPS as well as the Equal Employment Opportunity Commission while residing in California. Plaintiff also alleges that he was retaliated against and constructively terminated from the Oval in 2024 while residing in California. On September 24, 2025, all defendants jointly filed a notice of removal alleging this court has jurisdiction pursuant to 28 U.S.C. sections 1332 based on complete diversity of citizenship and an amount in controversy exceeding $75K. On October 27, 2025, defendants filed the present motion and requested this court to 1, dismiss plaintiff's claims for lack of personal jurisdiction under the Federal Rules 12b-2, or enforce the Georgia Forum Selection Clause in plaintiff's performer agreement with TPS and dismiss this action for improper venue under Federal Rules of Civil Procedures 12b-3, or 3, dismiss plaintiff's claims pursuant to 28 U.S.C. section 1404, forum nonconvenience, or in the alternative, transfer this action to the United States District Court for the Northern District of Georgia pursuant to 28 U.S.C. 1404. Defendants have separately filed a motion to dismiss plaintiff's claims under Rule 12b-6 of the Federal Rules of Civil Procedures because the court grants defendants' present motion to transfer this action to the United States District Court for the Northern District of Georgia pursuant to 28 U.S.C. section 1404A. The court need not reach the separate Rule 12b-6 motion. So essentially, Tyler Perry got his alternative. Of course, he initially just tried to get it dismissed, saying this court lacks jurisdiction over him, but it's going to get transferred to Georgia. Now, in making this ruling, the court did not make a decision on what state law applies, but I would, if I were to guess, I would think that once they get to Georgia, the Georgia federal court is probably going to apply Georgia law. And then what would happen, as you guys saw on the video, if they apply Georgia law, what will that do to Derek Dixon's claims? What would happen to his claims? Because you have now where, let me pull this up. The Tyler Perry lawsuit. If you guys recall, part of why they were overcoming the statute of limitation, was because it was in California, and they have one of those laws that gives you the look back, where they allow you to file claims that are past the statute of limitation, which is essentially what Braxton Wells was told. Your claims are past the limitation, and so we can't help you because Georgia law applies. Well, Derek Dixon just got an attorney that was trying to say that it's not Georgia law that applies, it's California. And of course, he just filed it and it was going to be up to the court, like what happened, whether that was going to stay in California or be moved. And now Tyler Perry has been able to get this case moved to Georgia federal court. And so he has all of these, as you all see, claims that are that are California-based claims. Now, will the court apply the California law? They can choose to, but I doubt it. I doubt in this case, based on that choice of law provision, that they will. And so it wouldn't shock me if he doesn't file a motion to dismiss again, trying to dismiss all of these claims. Because again, in California, they just gave you, and that's not in every state. In California law provides specific revival statutes for sexual assault claims, which revive certain claims that would otherwise be time barred if the plaintiff meets the statutory criteria, including allegations of a cover-up by an entity legally responsible for the assault. The claim may proceed under California law, even if it would be barred under Georgia law. So they're trying to get California to apply, is what they're trying to do. So make sure y'all hit the like button, please. Hey, Cooper Crew, good to see you. So that is the gist of what happened with his response to the motion to dismiss. Let me see if you guys have any questions, because again, if we pull up the actual court's order, let me see. I'm not going to go through all of the things. Hold on. So if you go over, of course, it's just a bunch of discussion. And let me see. I guess I'll go over some of it. They got the legal standard. I'm not trying to bore y'all for real. Let's go to the discussion. The court need not decide the complex issues of personal jurisdiction in this case because the court concludes that this action should be transferred pursuant to 28 U.S.C. section 1404A. A district court may also transfer an action pursuant to 28 U.S.C. 1404A, regardless of whether venue is proper or the transferring court has personal jurisdiction of the defendant. The court must first determine whether the forum selection clause and plaintiff's performer agreement are valid, because that issue informs the court's analysis under 28 U.S.C. Each of plaintiff's 4 performer agreement contains a forum selection clause, which basically is a clause that tells you, again, if you have any issues, what state law will apply, providing that disputes, quote, may be heard only in a court of competent jurisdiction of Fulton County applying Georgia law. Forum selection clauses are presumptively valid and enforceable and should control, absent some strong public policy of the forum that is offended by the clause. As the party challenges enforcement, plaintiff generally has the burden of demonstrating that the clause is unreasonable and unjust, or that the clause is invalid for such reasons as fraud and overreaching. A contractual choice of forum clause should be held unenforceable if enforcement would contravene a strong public policy of the forum in which suit is brought, whether declared by statute or by judicial decision. The court concludes that the forum selection clause in this case are valid. Plaintiff contends that the forum selection clauses are invalid under California Labor Code, which provides in relevant part An employer shall not require an employee who primarily resides and works in California as a condition of employment to agree to a provision that will require the employee to adjudicate outside of California a claim arising in California. So they're using this code to say that the forum selection clause shouldn't apply based on California's labor code. So then they go back and say Section 925 expresses California's strong public policy against forum selection clauses in employment agreements. Notwithstanding California's strong public policy, district courts have held that Section 925 does not control claims arising outside of California or claims by plaintiffs who do not primarily reside and work in California. The court concludes that Section 925A is inapplicable to plaintiff's claims because he either did not primarily reside in California at the time he entered the agreement or because he did not primarily work in California. Indeed, with the exception of the Finding Joy agreement, plaintiff resided in Georgia at the time he signed the agreement containing the Georgia forum selection clauses. And then it has all of the law. Plaintiff also argues that the forum selection clauses violate California's strong public policy against employment discrimination and harassment as embodied in FEHA. The court disagrees. The public policy exception to enforcement of forum selection clauses is narrow and will only rarely displace the presumption that such clauses are valid and enforceable. While California does have a strong public policy interest in protecting its residents from discrimination and harassment, this interest will not be contravened as long as plaintiff has some legitimate remedy for his claims. Here, plaintiff will be able to vindicate the same substantive rights in Georgia through federal Title VII employment claims and Georgia common law torts, including assault, battery, and intentional infliction of emotional distress. So they're saying in Georgia, they have some of the same laws. Furthermore, to the extent a choice of law analysis mandates the application of California law, a Georgia court can easily apply California statute. Granting the instant motion does not preclude the plaintiff from raising the choice of law issue in agreed upon form. Finally, to the extent plaintiff suggests that some of his claims may be time barred under Georgia law, the forum selection clauses nonetheless remain enforceable. Plaintiff agreed to such clauses at the time of contract, and courts routinely enforce forum selection clauses even when the result is application of a less favorable statute of limitation. So one of the arguments that Derek said was, hey, judge, if we move this to Georgia and they apply this forum selection clause in the contract, I may lose some of my claims. Like, I'm gonna need California because California has this look back statute. And the court is like, that's still not a reason, public policy based, for us to not abide by that forum selection clause and send this to Georgia. So based on this, even though the court really didn't make a decision on the choice of law, meaning the law that's going to apply to this case, I think Derek Dixon is aware, this is my opinion, that he would lose some of these claims, if not all of these claims, if he goes to Georgia. So it makes his case weaker, in my opinion. So there's that. So the conclusion is, for the foregoing reasons, defendant's motion is granted in part. This action is hereby transferred to the United States District Court for the Northern District of Georgia pursuant to 28 U.S.C. Section 1404A. And so this case was closed out. This case has been closed out in California, and now it's being moved to Georgia. And that is that. That is what is happening in the Tyler Perry case. Kelly said, I agree with the court. She agrees with the jurist on the bench. You said, okay, there it is, the statute. Yeah, that's what I think. Honestly, again, my opinion, I think when it was filed in California, there was probably a conversation that you were going to have to fight for it to stay in California, because he would not, if there is statute of limitation issues, he would not have the ability to file these claims. But again, California, like New York, had these statutes that they created of which you can look back for certain situations and perhaps be able to file despite in spite of the statute of limitation. Georgia doesn't have that to my knowledge. So this is the first step for Tyler Perry, probably try to get these claims dismissed. Again, he'll probably vehemently deny that everything happened like he did in the intro of his motion to dismiss, but ultimately for procedural reasons, he had a reason to try to get this either dismissed or transferred, and the court opted to just transfer it. So there's that. That is the Tyler Perry. Do you guys have any questions? Any questions? And I think you're wrong, Chris, but okay. You're absolutely wrong. There's a choice of law. That is the point of having a contract of choice of law. When I have artists that come to me and they want me to do their performance agreements and I am their attorney, I have a choice of law provision that if it's any issues, if we don't arbitrate it, we're going in Michigan because I'm not going outside of the state. If this is my client's contract, that's the point of a choice of law. As far as jurisdictional, he's not a dual resident. He literally, you can have houses in other places and they not be your main house. So I think this is a difficult case. Jurisdictional wise, I think the judge got it right. And I said that in my previous video with Braxton. I was like, chill out, because I get it. We read these pleadings and they seem so persuasive. And so we'll believe what the pleadings say. But until this is just an allegation, this is what they're saying right now. And then he has the time to respond. When Braxton Wells was talking, I'm like, he hasn't even been served yet. So we don't know. And I said, I eventually was like, yeah, he's going to challenge jurisdiction. I mean, it was just, why wouldn't you if you have a choice of law? He lived in Georgia for 30 years. His studio is in Georgia. That means you're probably coming to the studio in order to even perform whatever roles that you're doing. It's just, I think once he moved to California, they have better laws there that would benefit you if you're able to make them stick. Now, again, the Georgia federal court can say, we're going to apply California law too, but I don't believe so because they have a choice of law provision that says that Georgia law applies, which means that if the court honors that choice of law provision regarding what law applies, then Georgia law will be what applies in this case. So that's that. You said you love contract law. It's so boring, but it is what it is. Sometimes there are ways, again, of which they say these choice of law provisions are for public policy reasons or whatever reasons they shouldn't be applied as, even though they agree to it for whatever reason. There's always exceptions to the general rules. You'll learn that when you practice law. There's always exceptions, and your case may be the exception. Shoot, sometimes you may create law while you're in there or whatever because your case becomes the exception. But yeah, that's generally it. Bias in Georgia is not an argument. Let's see. You said it's a little boring, but it's interesting. Yeah, y'all make sure you hit the like button, subscribe to the channel. That is our Tyler Perry update for today. Looks like Tyler got his first W, where he's going to get over there and get it over to Georgia law. They'll probably then argue that Georgia courts, I'm sorry. They will probably next argue that Georgia law applies. And if Georgia law applies, that is the majority of this man's claims. They're California based. And he's using a look back statute as well to overcome some of those statute of limitation issues that he may or may not have. And it sounds like, according to the order, because I don't remember reading his response to the motion to remove it to Georgia, but it sounds like he mentioned that some of his claims would not be viable anymore because of the statute of limitation in Georgia. And the court said, well, that's not a reason not to move it to Georgia because you may lose some of your claims. It kind of is what it is. But anyway, y'all, that's it. Lisa said, Pam, is Tyler Perry still singing on the porch? So let's see. See if I missed anything, any comments that actually no. Hey Tracy, good to see you. Thank you so much. I'm on my way out of here too. That's why y'all getting the fast live or whatever. You guys make sure you like the video, subscribe to the channel. But yeah, we're gonna follow this case now. We'll be following it in Georgia, child. They actually have some hearings. I might be in Georgia. You know, I like to show up in Georgia, so there's that. All right, y'all. I'm out of here. So for now, he has one case still in Georgia and one in California. Who is in California? He doesn't have a case in California that I know of that are like this. Now he has other cases, I think, related to some copyright type stuff, but no. Thank you, Miss HLS. I did them this morning. I appreciate it. No, once the court decides to remove it to Georgia, the case is removed. Like literally, this California case is closed. If you go on the docket, it'll say closed at the top. So yeah. All right, y'all. See, I did a quick live. I'm so proud of me. I gotta go packing everything and yeah. So you guys have a great day. If something else happens, we'll be back. Next time I go live, it might be from better weather because it's like 8 degrees here in Michigan. So I'm going to some better weather. And maybe you'll see actual sunshine in the background or something. But thank you all, as always, for your support. And I'm going to holler at y'all later.